Sio, Danghodoa Dylan Turman. Hello everyone, I'm Dylan Turman, and it's an honor to present my research on the Cherokee Nation and its tribal court system. This presentation represents the culmination of my work for Professor Smith's Tribal Courts and Indian Country course. The Cherokee Nation's judiciary is more than just a legal framework. It's a testament to resilience, adaptation, and sovereignty. Today, I'll guide you through this story, from the nation's governance before European contact to its modern-day assertion of judicial authority. Before European contact, the Cherokee people governed themselves through a sophisticated system based on consensus and customary law. Leadership was decentralized, and disputes were resolved through community mediation rather than punitive measures. This deeply rooted governance structure was the foundation of the Cherokee legal system that would come to evolve over centuries. However, the arrival of European settlers introduced new challenges. The United States government's expansionist policies led to a series of treaties that tested Cherokee sovereignty. Among these treaties was the Treaty of New Echota. Executed in 1835, the Treaty of New Echota was particularly devastating. The treaty was signed by a small faction without the consent of Principal Chief John Ross or the majority of Cherokee citizens. This treaty ceded all Cherokee lands east of the Mississippi to the United States. It also led to the forced relocation known as the Trail of Tears, where thousands perished. Although the treaty also promised land protections in Indian Territory for the Cherokee people, these assurances were later undermined by federal encroachments and federal policy. Despite the hardships brought on by the removal era, the Cherokee Nation reestablished its government in Indian Territory, adopting their 1839 Constitution. This document created a tripartite government with an executive, legislative, and judicial branches, which was modeled after the United States system but distinctly infused with Cherokee traditions. Later, the 1975 and 1999 Cherokee Constitutions reaffirmed self-governance, further strengthening the nation's judiciary. Before 1975, the Cherokee Nation had very little control over its legal system. When Oklahoma became a state in 1907, the Cherokee judiciary was dismantled. This actually started earlier with the Curtis Act of 1898, which abolished tribal courts and put legal matters involving Cherokee citizens under U.S. federal and territorial courts. By 1906, the Five Civilized Tribes Act formally ended the Cherokee Nation's recognized government, leaving only a minimal structure in place. For decades, there were no official tribal courts. Cases involving Cherokee citizens went straight to state or federal courts. Law enforcement was handled by state authorities, federal agencies, and some BIA-funded officers, but the BIA didn't fully take over legal matters. Instead, it mostly managed trust lands and federal responsibilities related to Cherokee affairs. That changed in 1975, when the Cherokee Nation adopted its modern constitution. This was part of a larger federal policy shift during the self-determination era, encouraging tribes to reclaim self-governance. With that, the Cherokee Nation reestablished its judiciary, bringing back the District Court and Supreme Court to handle civil and some criminal cases involving Cherokee citizens. Today, law enforcement is handled primarily by the Cherokee Nation Marshal Service, though federal agencies like the FBI and U.S. Marshals still get involved in major crimes under the Major Crimes Act and court rulings like McGirt v. Oklahoma. Meanwhile, the Cherokee Nation Supreme Court now decides cases involving Cherokee law, citizenship, and governance, reducing federal court involvement unless it's a federal law, treaty rights, or jurisdictional dispute. The BIA no longer controls Cherokee courts today, but it still plays a role in specific areas like managing trust lands, distributing federal funding, overseeing regulations on land, leases, and mineral rights, in some cases, election disputes, and under the provisions of the Indian Reorganization Act, constitutional amendments, or approvals. For the most part, though, the Cherokee Nation operates independently, making its own legal and political decisions without needing BIA approval. Before we begin to analyze the Cherokee Nation tribal court system, I offer this powerful quote by the Honorable Bradley Letts. Before the adoption of various tribal statutes and a constitution in the early decades of the 1800s, the Cherokee legal system adjudicated disputes through the clan system. Clans were asked to decide on causation, to offer forgiveness, or to accept compensation. The 7 Cherokee clans maintained the fabric of Cherokee society, and it was from the strength of the clans that Cherokee laws received their force and energy. It appears the primary goal of Cherokee law was harmony. The Cherokee Nation's court system is deeply rooted in its constitutional authority, tracing back to the Cherokee Constitution of 1839 and later revisions. The judicial branch is headquartered in Tahlequah, Oklahoma, the capital of the Cherokee Nation. The Supreme Court and District Court function from this location, while satellite courts handle specific matters like child support enforcement and Indian Child Welfare Act claims within the nation's jurisdiction. Judges, including the Supreme Court justices, district court judges, and occasionally special masters, are appointed rather than elected. The Cherokee Nation Attorney General's office is responsible for prosecuting cases on behalf of the nation, while court clerks manage records and oversee legal proceedings. This system reflects both the nation's historical governance tradition and its modern constitutional framework, ensuring judicial independence and effective legal oversight. The Cherokee Nation Tribal Court handles cases involving Cherokee Nation citizens, covering family law, contracts, and criminal matters, among a number of other subject matters. However, its jurisdiction over non-members is limited and depends on federal laws such as the Violence Against Women Act, the Major Crimes Act, the Tribal Law and Order Act, and a number of landmark Supreme Court cases, which all allow prosecution for certain crimes. At the top of the judicial system is the Cherokee Nation Supreme Court, which is the highest authority. It reviews decisions from lower courts, ensuring that legal interpretations remain consistent and that tribal laws and sovereignty are upheld. Attorneys practicing in tribal courts are regulated by the Cherokee Nation Bar Association. To become a member, lawyers typically need a law degree and must demonstrate knowledge of Cherokee Nation laws. Some attorneys can also be admitted on a case-by-case or limited basis under the principle pro hoc vice. This system maintains judicial integrity while protecting tribal sovereignty and legal consistency. The Cherokee Nation Marshal Service serves as the tribal police force, enforcing laws and coordinating with federal and state agencies when needed. When it comes to prosecution, the Cherokee Nation Attorney General's office handles cases within the nation's jurisdiction. Historically, the Cherokee Nation resolved disputes through a council-based system, but today it does not operate a separate traditional court. However, traditional principles still shape legal proceedings, particularly in restorative justice and mediation efforts. In some cases, especially those involving elders and family law, Cherokee language and customs are taken into account. Some restorative justice programs even incorporate Cherokee traditions, focusing on community-based resolution rather than strictly punitive measures. This blend of modern and traditional approaches ensures that the Cherokee Nation's legal system remains rooted in cultural values while maintaining its effectiveness. As mentioned before, the Cherokee Nation Supreme Court is the highest legal authority, making the final call on tribal legal matters. If someone wants to appeal a case from the district court, it goes straight to the Supreme Court, no in-between steps. Federal courts generally stay out of tribal cases, unless there's a federal law, treaty rights, or a jurisdictional issue involved. This helps protect tribal sovereignty and keeps legal authority within the nation. Not every dispute goes straight to court, though. Issues like tribal citizenship, business regulations, or government decisions might have to go through an internal appeals process first. It's a system designed to keep legal matters within the Cherokee Nation while balancing its relationship with federal law when necessary. Doing a deeper dive into the subject matter jurisdiction of Cherokee Nation tribal courts, the Cherokee Nation District Court is where cases start. It's the trial court. It handles a wide range of legal matters, including criminal, civil, and family law cases. That means everything from divorces, child custody, contract disputes, land and property issues, protective orders, and even some criminal offenses involving Cherokee citizens fall within the purview of the subject matter jurisdiction of the Cherokee Nation District Court. But for major crimes, however, federal courts still have jurisdiction. If someone wants to challenge a decision of the Cherokee Nation District Court, they take it to the Cherokee Nation Supreme Court, which acts as the final authority on appeals. This court reviews lower court rulings, handles constitutional questions, settles some election disputes, and decides tribal citizenship cases. It also has the power to issue writs like habeas corpus and mandamus to ensure due process. Outside of the courts of the Cherokee Nation, there's also the Bureau of Indian Affairs, which doesn't directly control Cherokee courts, but still plays a role. It manages tribal trust lands, federal funding, and regulatory compliance, including oversight of land leases and mineral rights. It also has a say in tribal constitutional amendments and approvals, ensuring they align with federal policies. Mostly, however, the federal government's role is entirely administrative. There are some nuances to this, particularly with regard to certain legislative frameworks, like the Stigler Act or the Indian Reorganization Act, which does require the federal government's approval to ensure consistency with federal policies. So while the Cherokee Nation runs its own legal system, federal oversight still comes into play when it comes to land management, major crimes, funding, constitutional changes, and any particular legislative framework where the federal government has the final say. I conclude my presentation with the Cherokee word for justice, duyugda. If there is a common thread throughout this presentation, it is just how much the Cherokee people have endured. From removal and forced displacement to the loss and restoration of their courts, the Cherokee Nation has faced countless challenges, yet through it all, justice has never been abandoned. Cherokee justice is not just about laws or punishment. It's about balance, survival, and resilience. It is about restoring harmony, ensuring accountability, and carrying forward the strength of the people. Just like the sacred fire that never goes out, justice among the Cherokee people is something that endures, adapts, and continues to guide the nation forward. Thank you for your time, and I look forward to any discussion or comments you may have regarding my presentation.